Supreme Court makes a major ruling in favor of landowners. And I like to include some recent legal advances in addition to the classic pieces that we have built Business Law 101 around, and this is certainly an important one. This is Dr. David Shine, and welcome to Business Law 101. In 1970, Richard M. Nixon signed into law the Environmental Protection Act. This powerful law helped put America on track to clean water, clean air, and clean land. A couple years later, Congress passed the Clean Air Act and the Clean Water Act. And not surprisingly, many government agencies take the lead and then keep running with it. The EPA is responsible for the waters of the US, and the concept is tied to something called navigable waters. Landowners, including farmers with little water ponds that disappear in the summer weather, have been haunted by EPA claiming jurisdiction over the puddles or the lack of puddles that the dry real estate has. Yes, folks, I don't make this stuff up. So it's been very troublesome for landowners. And think about the additional bureaucrats that are required to police all this additional real estate that really wasn't intended by Congress. So the issue's been a football for well over 20 years. And the Supreme Court case in 2001 limited the coverage of the EPA for certain waters, but the EPA almost immediately went back and expanded its reach to just about any of the waters, or about 300 million acres. Again, think about the additional manpower required by the agency to police these additional grounds. It has been an expensive nightmare for landowners as well. This summer, the Supreme Court ruling in Sackett versus the EPA may have finally reined in the EPA. The case involves a Sackett family who bought a beautiful parcel of land near Priest Lake, Idaho in 2004. Think about the year, folks. They began building their dream home. It involved grading some land that was near a ditch that fed into a creek that fed into the lake, which is completely intrastate. The EPA sued them and wanted all construction undone, not just stopped, but undone. 19 years later, yes, folks, 19 years later, the Sacketts won a unanimous verdict in the U.S. Supreme Court. The Sacketts' efforts are critical for the future, since the ruling will curtail this runaway agency and help landowners. The court held that the EPA can only control wetlands, and we're going to quote this, as a practical matter indistinguishable from the waters of the United States. The waters involved with the land in question must be connected on a continuous basis to interstate waters. The EPA issued a new rule in late August 2023 to implement compliance with this new decision. As always, let the landowners beware. Be sure to consult with your attorney regarding the use of land before you begin any changes or construction. Dr. David D. Shine for Business Law 101. Thanks for joining us. If you've enjoyed this episode, please subscribe on your favorite platform.